Welcome to our Beverage and Diamond Podcast. I am your guest host, Alan Stern, a lawyer in our Seattle office, and I am here with John Cruden, a principal in our Washington, D.C. office. Before joining Beverage and Diamond, John served as Assistant Attorney General of the Natural Resources Division of the U.S. Department of Justice, and he has lectured widely on Supreme Court practice. Welcome, John.
Thank you very much, Alan. What case are we talking about?
So we're talking about Atlantic Coast Pipeline versus Cowpasture River Preservation Association. On February 24th, the Supreme Court heard oral argument in this case. It involves examining the U.S. Forest Service's authority to grant rights of way of a natural gas pipeline that would traverse the Appalachian Trail. John attended the oral argument, and he's here with us today to give us a firsthand account.
Thank you, Ellen. It actually was an exciting case. There were three different Supreme Court advocates, all of them experienced, all of them excellent. This whole case involves a pipeline valued at about $8 billion by Atlantic Coast Pipeline, which is a joint venture of Dominion Energy and Duke Energy. It's a 600-mile, 42-inch diameter pipe that's going to carry natural gas from West Virginia to North Carolina. There's an increased need for natural gas in the Mid-Atlantic because coal-fired power plants are being shut down and gas-dependent industries are expanding. And as everyone knows, natural gas has a significant less carbon emissions than coal-fired power plants. But the critics dispute the need for new fossil fuels and do not like the fact that this would cross underneath the Appalachian Trail. The proposed route for the pipeline crosses steep mountain ranges and then tunnels underneath the Appalachian Trail within the George Washington National Forest. The court is being asked to construe several statutes, including primarily the Mineral Leasing Act, which promotes pipeline rights of way and other energy development on federal land, but does not include lands in the National Park System. And the other statute of interest is the National Trail System Act, which gives the Appalachian Trail, which designates the Appalachian Trail as a national scenic trail and gives the Secretary of Interior administrative responsibility, and the Secretary has delegated that to the National Park Service. Today, the Park Service administers the 2,100-mile trail as one of its 419 official units. In 2017, the Forest Service approved the route and issued a special use permit for the pipeline. And it's that permit, the Forest Service permit, which is at the heart of the case, and which was first reviewed by the United States Court of Appeals for the Fourth Circuit, which vacated the permit in 2018 on the grounds that the entire Appalachian Trail, all the way from Georgia to Maine, is really part of the National Park System, so that the Forest Service really didn't have the authority to issue the permit that it did. The United States, on behalf of the Forest Service and the pipeline, then sought certiorari from the decision. The Supreme Court accepted, and that was the case that was argued then on February 24th.
Interesting. So I know you and two other members of our litigation team, Jamie Oslander and Peter Schaumburg, filed an amicus brief in the case. What was the significance of that brief?
We had a number of clients who came to us seeking our assistance in filing an amicus brief. We did both at the certiorari stage and then at the merit stage. We did so on behalf of the National Associations of Manufacturers and over 20 other organizations, to include the National Mining Association and the Chamber of Commerce. Our amicus brief really made 3 points, and we made it both at the certiorari stage and at the merit stage. We said, first of all, that the Court of Appeals decision effectively precluded a critical energy resource development and transportation by requiring project proponents to go to the National Park Service. And because the National Park Service really could not approve such a permit, it was going to mean that every one of the individuals seeking approval would have to go to Congress and get their own special legislation, which we did not think was workable. Second, we argued that the decision, because it was effectively prohibiting energy transportation, would threaten the United States energy security while providing absolutely no additional benefit to the Appalachian Trail. And unless the court reversed that ruling, it was going to jeopardize existing and future pipeline approvals in that important area of the country, as well as along the 2,000-mile Appalachian Trail. So that was point number two. Our third was that there was a number of really unintended consequences, we thought, by the court's Fourth Circuit's decision, because if the Appalachian Trail was effectively a barrier or a wall, it was going to impact well beyond pipeline projects and impact perhaps roads and bridges, electric transmission lines, telecommunication lines, water facility, even grazing areas, anything that was going to cross the Appalachian Trail. So we filed that amicus brief on behalf of all of our clients, and we know that it had an impact on the ultimate case.
So everyone wants to be their best when they go in front of the Supreme Court. I presume there was a moot in this case before argument. Did you participate in that?
I did. The Chamber of Commerce very often runs moot courts for cases that they were involved in, and since our amicus brief was in part on behalf of them, they both organized the moot court, and I was asked to be a judge in the moot court. We did it in the offices of the Chamber of Commerce. Paul Clement, a former Solicitor General of the United States, presented at the moot court and did it just as if it was a real court. And interesting now, in just this term, Ellen, the Supreme Court changed their procedures so that your first 2 minutes of your argument is done without interruption. There's a white light that goes on at the end of 2 minutes. Well, in this case, Paul Clement was sharing argument with the government. Tony Yang was arguing on behalf of the Forest Service. So each of them had 1 minute of uninterrupted time, and we practiced that. We practiced questions we thought the various court judges would ask, justices would ask, but we also practiced having an uninterrupted 1 minute. And we all critiqued it. We all added to it. Paul Clement is a very, very effective Supreme Court advocate, and he assured us afterwards that the moot court really assisted him in the preparation of his oral argument.
How did the Supreme Court oral argument go?
I mean, I would say all of the advocates, Tony Yang for the government, Paul Clement for the pipeline, and then Michael Kellogg for Cowpasture, were superb. They were all extremely well prepared. They all had obviously gone through maybe not one, but several moot court. And the justices were all prepared. They came prepared to ask questions. They presented theories that were not in the briefs, but which they thought might help resolve the case. So it was a very, very, very active argument by very experienced counsel. My own view is that the government will probably prevail in this particular case, but there isn't any clear consensus in my mind as to the grounds of reversal. But let me give you just some of the highlights of the argument. Now, remember, the fundamental issue here is whether or not the National Park Service has jurisdiction over the pipeline decisions or the Forest Service does. And that is an intense statutory argument. And so everyone argued individual parts of the statute that benefited their side. But at one stage, I believe it was Justice Alito who presented an entirely different theory that he said was narrow and would resolve the entire case. And he said, these were his words, when I think of a pipeline that is 600 feet below the surface, that does not seem like a trail. So instead of having to draw the distinction between the trail and the land, why can't we just say that the trail is on the surface and something that happens 600 feet below the surface is not a trail. Well, if that was acceptable, then there was grounds that wasn't really argued, but it would have narrowly resolved the case. Right from the very beginning, Michael Kellogg presented the argument to the contrary, that was not a good reading, and argued, as you would imagine, that the trail in this jurisdiction extended all the way down to the bottom. One of the lighter parts of the argument is when Justices Breyer and Alito and Justice Lena Kagan all asked Clement, obviously representing the pipeline, what he thought about the plausibility of the narrow ruling that Alito had surfaced. And he said, well, first of all, that was not our position. We have a different argument. But then he said, I represent the Atlantic Coast Pipeline. It's not my job to resist winning this case on narrow grounds. And so everyone laughed, but we understand that, that is one possibility. But I think it's more likely that the case goes down on broader grounds, and a number of the justices, and certainly Clement, referred to an earlier environmental case called Whitman versus American Trucking Association. And in that case, Justice Scalia had famous lines. He said that Congress does not alter the fundamental details of a regulatory scheme in vague terms or ancillary provisions. It does not, one might say, hide elephants in mouse holes. And so Clement referred to that, and so did others, kind of Justice Kavanaugh as well, that this decision has significant consequences. Kavanaugh said, you would expect to see clear language like that to generate significant consequences of this position. And so I think it's probably more likely that the court does the broader statutory argument, taking the position that the Forest Service was correct in having authority. The government argued very effectively that this was a status quo, that there had been decades and decades and decades of experience having the Forest Service making these decisions, and that was appropriate because even though the National Park Service was being administered the trail, it was surrounded by the George Washington National Forest, and that was clearly within the jurisdiction of the Forest Service. The other reason that I would think that the government's position is likely to prevail is not just what I've said so far, but toward the end of the argument, we sort of got a couple of justices tipping their hands. Chief Justice Roberts said at one stage, it really does erect an impermeable barrier, referring to the lower court decision and the Appalachian Trail, making the argument that we had presented in our amicus brief that this almost became a wall. And then second, Justice Sotomayor said in her view, the environmental groups had not fully satisfied the parade of horribles that have been put forth by the petitioners. And remember, our third argument in our amicus brief was that there were a number of unintended consequences way beyond pipeline, that having a rigid barrier that would require congressional approval for every single decision was not only unworkable, but was in fact a parade of horribles. So for all of the reasons that I just stated, my belief is that the government's position is likely to prevail, but I would also say it's also unlikely that there will not be concurring and dissenting decisions, as this was such a complicated statutory argument, but a very, very, very significant case for the future in interpreting public lands and talking about energy development in the future, and talking about how we're going to look at the Appalachian Trail.
Thank you, John. That was an excellent synopsis. So given your significant level of knowledge and experience, what advice would you offer to in-house counsel at similarly positioned companies if they find themselves in a case of this nature?
After the argument, we met with a number of companies and individuals and even academicians to talk about the significance of the case. And I came away with that thinking how important it was to have amicus briefs in a situation like this. I've been for years in the government putting together the government brief, and I remember full well how good it was to have an amicus brief that could make arguments that we could not make. Not that they were not accurate, you just have page limits. And also you have limits in your time. And sometimes individuals, whether or not they're NGOs or whether or not they're other companies or even academicians, provide a whole nother view of the case. And I really do believe that in this particular case, our amicus brief made a difference because, again, we could make arguments and present evidence on behalf of our clients that were valuable to them and safeguarded their position, but also advance the rule of law by presenting information to the court that they might not get through any other way. So I know that all of these are time-consuming and are costly, and in the Supreme Court, you want to be at your highest game in what you present. But I came away thinking more than ever that amicus briefs really can make a difference, and certainly the Supreme Court puts weight on that.
We need to wrap up this discussion, but what would you say is the most important lesson, maybe the one takeaway from this case?
I want to add something I did not say, and then I'll answer your question. And maybe it goes to my last point anyway, where I'm going to talk about professionalism. At the end of the argument, as everybody else was getting ready to walk away, Chief Justice Roberts said, Mr. Clement, would you stay around for a minute? And then he turned to all of us in the audience and said, we want to honor Paul Clement, former Solicitor General. This was his 100th oral argument. And I thought, what a great moment of professionalism. What a great statement. A statement, obviously, because Paul Clement is a friend, is such a good oral advocate, but that the Supreme Court took time to actually add up the numbers. And that's the one takeaway I would have for all of you listening on the podcast today. And this is a very controversial case. You can go online and get lots of pro and cons of it, portrayed as an environmental issue and portrayed sometimes mistakenly about what was going to happen to the trail. But in the court, this was absolutely professional. The justices were prepared. The advocates were superb. The advocates for Cowpasture, Michael Kellogg, was absolutely wonderful. He had a great presentation. And it made you feel good about our profession. It made you good about how serious this was examined. And then when the court makes a decision, however it makes, you'll have greater faith in that, knowing just how disciplined and how good the process was among the 9 justices, among the Court of Appeals, among all the advocates and all the participants that will ultimately lead to a binding decision in this case.
Thank you so much, John. This brings us to the end of our time. Our listeners can learn more about the argument in Beveridge and Diamond's nationwide litigation and appellate practices at www.bdlaw.com. Thank you for listening.